What were you given? Why are you being so coy? What were you given?
I was given that the father dropped the child off. The child was taken by the babysitter, and the dad was driving to work and received a phone call very shortly thereafter that Hannah had collapsed, something along those lines.
And who told you this?
To be honest, it's in the medical record, I believe, in Epic. It's Kelly Hiley probably has supplied that to me, the prosecutors.
So medical records? Were you given any other documentation? How about a police report?
I don't usually see a police report.
How about text messages?
No.
How about phone log?
No, we've already discussed.
What time was 911 called?
I don't know.
What time was Hannah's father called?
I don't know.
What time was Hannah dropped off?
I don't know. I think she was dropped off about an hour before she went to Fort Hamilton, or within the hour, I was told at some point.
So you had all this information in your head about the timeline and the importance of the time, and you write me a report that says rapidly. You use that term, that adverb, rapidly, knowing the critical aspect of timing in this case, and that's what you choose to use, right? Yes?
Yes.
And for the first time in the history of this case, on cross-examination, you bring up a unit of time within seconds. Yes?
Yes.
All right.
All right, so that's cross-examination by the defense of the radiologist that was presented by the prosecution in the case. Taking some hard questions. Let's listen to some more, please.
Summer of 2016, in this Brad Young case, while testifying and under oath, are you able to make a determination from a progression forward in time as to when the insult would have occurred in the reverse from the initial image? Maybe you have to look at me. Do you remember being asked that? Do you remember being asked that question?
Now that I've read it, yes.
Okay. And looking at me, do you remember your answer? Do you remember your answer?
I don't remember exactly what I said at that point, but I can tell you what I would say now, which I would guess.
No, we're not doing it that way. We're doing it under the rules of evidence. So you don't remember what you said?
No, but
Okay. You don't remember what you were said, right?
Correct.
Okay. You said, yeah, I can't look at this image and say it occurred 3 hours ago. I can't look at it and say, exactly when it occurred. But what I can say is that in the two hour, there's been a pretty significant progression of the brain swelling, and so I would expect the injuries to have occurred about the time the child actually presented to Atrium, somewhere close to that time period. I certainly wouldn't expect this to have occurred from a motor vehicle collision 3 or 4 days before. That was your answer, correct?
Correct.
Okay. And then, looking at me, you were asked, and when you say close to the time the presentation at Atrium, that would be then within hours as opposed to days. Do you remember being asked that question?
Not necessarily.
You've looked at the transcript, and I'm not making it up, correct?
Correct.
You were asked that question. Yes?
Yes.
And you responded under oath. Yes?
Yes.
As an expert? Yes?
Yes.
All right. A year and a half ago? 2 years ago? Correct? Yes?
Yes.
Okay. And you, looking at me, do you remember what your answer was?
I've looked at my answer.
Okay. And you said correct. Yes, within hours. Yes?
Yes.
Okay. On direct examination, I heard you say, I can't say the bleed happened within 1 hour or 20 minutes. Or 20 minutes. I correlate my findings with what clinically is going on with the case. You said that?
Correct.
Okay. So, in the Brad Young, you're talking about hours, right?
Correct.
Right.
The injuries in this child were very different than the injuries in the current case.
Okay. On direct, talking about this case, you said an hour or 20 minutes. Yes? Yes? On direct?
No, what I was saying is I can't look strictly at the imaging and say when those injuries occurred.
Okay.
That's why you have to correlate with the child's physical examination and say these are significant injuries. Just like a kid who's involved in a motor vehicle accident, I can't look at it and say the motor vehicle accident occurred today or yesterday, but I can tell you from the time those injuries occurred, that child would not be normal.
That's the radiologist under cross-examination by the prosecution in the Lindsay Parton case. Gene, what do you think?
Well, a couple things. Number one, I thought the cross-examiner was doing a very good job of controlling the witness. There were a couple of testy exchanges that I thought he didn't need to do, but he's locking her in. Number two, I just remembered this. In Florida, correct me, Bob.
Bring it in quick.
In a criminal case, you can take depositions in criminal cases.
And you can use it against them? Absolutely. Sorry, Gene, got to go to break. We'll be right back. Okay, welcome back. My name is Bob Bianchi. We'll be taking until 3 o'clock. So in the Jonchuck trial, as you know, they've had a lot of debate about the competency of the defendant. In this case, the court has appointed 2 independent medical experts to give a conclusion as to whether or not he is competent to continue with trial. One of them is Richard Cipriano. Just happened in court. Let's take a look.
Yes, sir, I did.
And what caused you to conduct that interview?
I received a court order from the judge to do a competency evaluation on Mr. Jonchuck.
And did you do that have you just recently completed that evaluation?
Yes.
And could you tell us what your opinion is regarding Mr. Jonchuck's competence to proceed?
He's competent to proceed.
No other questions, sir?
Any questions from the state?
No, Judge.
Okay. Defense, are you stipulating pursuant to Dr. Foreman and Dr. Cipriano that he's competent to stand trial?
Judge, we can't stipulate that he's competent. We will stipulate that the court can make your ruling based upon the reports of Dr. Foreman and Dr. Cipriano.
Okay. You want to say anything, Mr. Bowman?
Well, if that's the case, before Your Honor makes a ruling, I would ask Dr. Cipriano if he could just put on the record the facts and details
That's
upon
a good
which he's
idea.
making his opinion.
Do you want to question him about that?
I think that he could just put on the record why he's formed his opinion and the 6 criteria without necessarily be questioning him. I think he could,
Okay.
could do that.
Can
on
you
his own.
tell us pursuant to the 6 competency criteria? Do you have those?
Yes.
Okay. If you could tell us, go through each criteria and any information that you would customarily give. Thank you.
I had asked him what he was charged with. He told me first-degree murder. I asked him if he could explain the allegation. He told me that it was alleged that he killed his daughter, Opie. I asked how that happened. He said how she passed. He said drowning. And then I asked him how did they connect him to the crime. He said a cop saw me do it.
Okay.
I'd asked him then the possible penalties. He told me life in prison or not guilty by reason of insanity, and that the death penalty had been taken off the table. I asked him then about the adversarial nature of the proceedings, in particular what the role of the judge was, and he told me act as a referee, keep order in the court, supposed to be neutral. I then asked him about the role of the defense attorney. He said to defend me and to protect me from the state side. And I asked him what he meant by that. He told me to have doctors do evaluations. I then asked him the role of the prosecutor. He said get a conviction and work with the defense in some areas in the court, in particular as far as working out a plea deal. That was my understanding. I asked him to provide the definition for the terms not guilty. He told me there was no conviction. Guilty meant that the person did it. No contest. You throw yourself at the mercy of the court, and it's usually accepted as a guilty plea. Not guilty by reason of insanity, he described as at the time of the crime he didn't know right from wrong. On further inquiry, I asked, is that for any particular reason? He said due to mental illness. I then asked him about a plea bargain. He says that the state and the defense works out for lesser time. And I asked if he had to plea a certain way. And he was a little bit vague on that. So, but
What was he vague on?
I asked him what a plea bargain was. And he told me that the state and defense work out and give you lesser time. And I asked him, well, you know, in a bargain or a deal, there has to be some reciprocity in there. And he told me that he eventually said he'd have to give up a guilty deal, essentially is what he said.
Okay, welcome back. That's the court's forensic psychologist breaking down the conclusion that he believes the defendant is competent to continue with his child. Gene, what do you think of his testimony in terms of, and explain to our audience why he was asking the questions he was asking?
He just wants to make sure, number one, that he's lucid. Number two, that he understands basic concepts like an indictment, allegations. And he asked him about what a guilty plea was. Just basic things to get out from him that he is not delusional, he's not seeing demons, and that he can understand what's going on in the courtroom. They were very good questions.
Right. Understanding the nature of the proceedings is really the bottom line to a competency to stand trial. Of course, again, I emphasize competency to stand trial and insanity defense are completely different legal animals. Let's listen to some more of the doctor.
Doctor, before you began your evaluation, were you able to review a videotape of a court appearance yesterday where defense counsel advised the court of the areas that the defense team was concerned with Mr. Jonchuck's statements? And
Yes.
Okay. And you had an opportunity to hear that entire court appearance?
Yes, it was quick, and I did my best to write down the notes.
Did Mr. Jonchuck, in your evaluation, did he tell you about each and every one of those?
I can't say that he did because, as I said, it was. I looked at the video. I wrote as quickly as I could, and then I asked what I could recall.
Okay. As to Mr. Jonchuck's belief that he heard things in court on Monday, did he tell you anything about hearing things in court on Monday when there was no court in session?
I can't say specifically. As I said, I was presented with the video. And as far as Monday, Tuesday, I know that was mentioned in there, but I didn't query him on that.
Okay. There was also an indication that Mr. Jonchuck heard one of the defense experts testify about Dr. Emily Lazaro. Did Mr. Jonchuck tell you anything about that?
I didn't inquire. I did mention something about Emily, and he told me it was Dr. Lazaro. And to pinpoint what he said and what I can't really answer that question.
Okay. Did he tell you about any hallucinations that he had back at the beginning of the trial involving Dr. Lazaro?
I recall from the video that apparently he looked at Dr. Lazaro and I'm not sure if he made a cut. I think he said, have a nice night, I think is what he said. And she kind of smirked at him. And I asked, was that have a nice night? Was that being cordial or not, or otherwise? And he said otherwise.
And that was in regards to something he said happened here in the courtroom?
That's correct.
Okay. And did he relate to you any events that happened in the jail regarding Dr. Lazaro?
Yes, he said that he's in a one-man cell and that he heard a voice outside the cell which he identified as Dr. Lazaro, and that person had made comments, I think something to the effect about it, if I may.
Sure.
He told me initially it was directed at himself and his daughter, and then subsequent later on he said it was just at him, but said something to the effect, you're going to burn in hell if you don't die. That was what he has told me that Dr. Lazaro said, and then subsequent to that he was informed by his counsel that Dr. Lazaro, it wasn't Dr. Lazaro because she wasn't in the area. So he does state that he did hear that statement by somebody.
Okay, welcome back. So that is the court-appointed psychologist that also, there's been 2 medical experts had an opportunity to review. The fact is, this doctor, as well as the first doctor, come back as him being competent. So that is both a psychiatrist as well as a psychologist, which is what we were just listening to. Listen, we're waiting to get back for court to resume in the Jonchuck trial. Gene, I'm curious about your opinion about this, and I think it could vary from state to state. But do you see, let's get to a really nuanced thing here. We know competency to stand trial deals with whether you can assist your defense meaningfully at a trial, where insanity is at the day of the incident, whether or not you were able to appreciate the rightfulness or wrongfulness due to a mental disease or defect, 2 different things. But does in any way possible a defense attorney try to mush those 2 together? Is any of this stuff about him being incompetent for all those months prior to trial and what's occurring now, is that a valid argument for an expert to say it shows the guy's got a continuing course of mental disease and defect?
If I'm a defense attorney, I'm going to mush just like polenta, okay? Because you're trying to show that at the time he allegedly killed Phoebe, that disease and defect continues 1, 2, 3 years later. So you want to mush them. And if I'm a defense attorney, the arguments for insanity are going to be similar to the arguments for incompetency and vice versa.
Yeah, I mean, and I just another strange question. Have you ever been involved in a scenario where maybe these attorneys, if they are witnessing some really bizarre things, and I'm hearing things, and the doctor's outside my jail cell, and witnesses are talking to me when they're not in court, it could potentially create a scenario where the lawyer becomes a witness.
Oh, absolutely. And that's what's uncomfortable about a competency hearing, because a lawyer is one of the best witnesses in establishing that someone is or is not competent. So it puts them in a very uncomfortable position because they then become a fact witness. I did have to tweak you a little bit, Bob. I made a comment about polenta. You said nothing.
That's because I told you before I don't like polenta. If you said it was like making a braciole or a meatball, I would have been all over it, Gene. Last question, though. I'm curious. With what's the rule, and I think it differs, and I think it's highly within the discretion of the court, when during the course of a trial, a lawyer has to become a witness, which typically you're not allowed to do?
Well, I don't think there's a rule of evidence on that, other than, you exclude the witnesses. It's sort of an ethical obligation. Anytime I had a case where a lawyer was a witness on a key issue and they're representing the defendant, they had to get off the case. Same with a prosecutor. A prosecutor cannot be a witness in his own case.
True, but those instances in which a defendant is in the middle of a trial, and unlike a prosecutor, a defendant has a right to a counsel of his choosing or her choosing. It's a constitutional right guaranteed to them. I've seen circumstances where courts handle it differently, especially when there's 2 lawyers there. They've allowed the person to go in as a witness and come back out and continue to represent, or they've basically let him come in as a witness and said, you can no longer be part of the case, your co-counsel can continue.
Yeah, but probably in those cases, I'll guarantee you that the defendant did not object, the co-counsel did not object, and I assume the prosecutor did not object because they want to get this trial moving. They don't want to, slow it down. So that's probably happened. I didn't see it often in any of my cases, though. Yeah, it's always a tricky thing. Well, listen, guys, it's been a fascinating case going through the differences between competency and insanity and what has gone on in this case. But this trial will go on because Jonchuck is capable, according to the judge's ruling. Going to break. We'll be right back.
Over 50. Did you know you could be taking advantage of everything AARP has to offer right now? Join today for just $12. Find out what 37 million AARP members already know. Benefits start instantly.
It's AARP.
Are you joining AARP?
Actually, I just did.
But is it worth it?
I enrolled at 7:02, saved on concert tickets at 8:10, read a great article on investing at 9, found a sweet travel deal at 10:15. I used the caregiver finder for my dad, and done. Discounted movie tickets.
Call or go to getaarp.org to join today for just $12, and your second membership is free. And get instant access to discounts on eye care, prescriptions, savings on travel, dining, and deals from top retailers. So many ways to save. Instant resources, tools, and tips to help manage your money, maximize your health, and so much more. AARP is mobile. Get alerts to savings and events near you. And AARP is the largest advocacy group for people over 50. Your voice will be heard.
I love the local retail discounts. AARP absolutely pays for itself.
I'm nowhere near ready to retire, and AARP has been a tremendous resource for that.
I get reliable financial tools and tips. And we check out the hotels, the dining. AARP saves us a lot of money.
Join today for just $12 for your first year. That includes a second membership free. Plus, you get the award-winning AARP The Magazine.
I love the magazine. Everything in there applies to me.
Benefits for both memberships start instantly. So call or click to join AARP today, and you get this travel bag and AARP The Magazine free.
Call 1-800-411-8550. That's 1-800-411-8550.
Or go to getaarp.org.
Welcome back. My name is Bob Bianchi. Be here to 3. Gene, Jonchuck's getting ready to resume. We hear some activity in the court. Our producers will let us know when the trial resumes to any level of significance. So they will proceed. This is the stuff the jury never gets to see. They will proceed after this lengthy battle and try to get back into a rhythm, the defense, of presenting some of these fact witnesses. Now, I think I go back to the point I said to you over and over again that the motive is going to be very, very important here. While the prosecution has to prove motive, I think it's more significant in an insanity defense than it is in any other kind of case.
Oh, absolutely. Motive's not an element of the crime. We all know that. But you're right. In an insanity case, if you can show there's some objective motive for why he allegedly did what he did, that defeats an insanity defense completely, in my view.
Right, and him being at the family law, it's kind of a weird thing. The family lawyer thing cuts both ways. He's there with regard to trying to maintain custody, makes this comment, well, this something to the effect that this will be all over with tomorrow. That lawyer is so freaked out about the odd behavior that they contact 911. So in a certain sense, it kind of provides motive, i.e. the ex-girlfriend and the child. But by the other side, it cuts towards, it was so concerning that she calls 911 and this guy's running around trying to get baptized and exorcised. And
that goes to burden of proof. They got to prove by clear and convincing evidence that one motive it far exceeds the other motive. It's not preponderance. Right, and we see that right now as we're looking inside the court that there looks like there's a witness on the stand, and I'm told we can go in the court. Let's take a look.
And I think testing that you did during your evaluation of Mr. Jonchuck?
Yes.
Did you administer any type of testing during the 3 times that you met with him?
Yes, I did.
And could you explain those?
I administered, as I indicated yesterday, the structured interview reported symptoms designed to identify people exaggerating or fabricating symptoms of psychosis, more serious symptoms like hearing voices, seeing things, being terribly impaired cognitively in terms of how you're thinking or what you're thinking. Paranoid delusions, grandiose delusions, things like that. The results of that test indicated no attempt by Mr. Jonchuck when I evaluated him to exaggerate or fabricate. I also administered 2 different but very similar tests. One's called the Mini Mental State Examination, and one's called the Montreal Cognitive Assessment. These are very gross, abbreviated measures designed to identify people experiencing significant impairments in their cognitive functioning, in things like attention, memory, understanding language, expressing language. But they're very brief measures designed to only identify the most gross impairments. Okay. And I administered each measure. I saw him 3 times. 2 of those occasions, I administered one of those measures that are very similar in terms of what they do. During my first meeting with Mr. Jonchuck, there were some indications that his attention and concentration was impaired. And when I administered it the second time around, he generally did better. But I still had some concerns about problems with attention and concentration, but certainly not that they rose to the level that he was unable to interact with me or understand what I was asking him or express himself and participate.
Okay.
And then finally, I administered a test called the Personality Assessment Inventory. It's a self-report test, right? A paper and pencil test where you're asked about life experiences, you're asked about psychiatric symptoms, some things like depression and anxiety. You're asked about your history of contact with the legal system. You're asked about your use of drugs and alcohol. The results of that test indicated that he was being straight. He wasn't exaggerating and fabricating problems, nor was he denying or minimizing, right? Because I wouldn't really pay attention to the results of the test if there were indications of exaggeration or fabrication, or he was trying to hide problems. However, I administered that test twice during 2 of the meetings. The first time, he answered similar items in very inconsistent ways. There's over 300 questions on the test. Some of the questions get to similar kinds of things. So one of the things we do is we look at how you answered this question, and we look at how you answered this question that are very similar. And if you answer enough of those questions inconsistently, we don't have much confidence in the results of the test. Either you weren't paying attention, or your attention was impaired, or you were doing the old Christmas tree approach to taking a standardized test. So in any case, the first time I administered that test, I didn't even bother to interpret the results because there were indications that he just wasn't responding consistently. I asked him about that.
Okay.
When I saw him next, he said, well, if you remember, doctor, you sort of administered that test at the end of the session, and I was pretty distressed and distracted and upset. Maybe that's the explanation, but I promise I was trying my hardest. So I said, let's give it another try. We gave it another try. He answered the items in a more consistent manner, consistent enough so I had confidence that I could look at the test results and make sense of them. No indications of exaggeration or fabrication, no indications of denying problems. And when I looked at the results of that testing, it suggested a whole range of problems, including difficulties with depression, difficulties with anxiety, acknowledging a history of substance abuse, acknowledging a history of contact with the law, acknowledging a history of problematic relationships with other people, volatile, intense relationships, not good relationships, and it also suggested emotional lability, poorly controlled emotions. Now, keep in mind, that test tells me mostly about how the person's doing as he sits in front of me. Some of it also, of course, gives me information about the past, like whether you've ever abused drugs or whether you ever abused alcohol or whether your relationships have been a problem for you in the past. So all of that is descriptive, I think, but it's important that I put those results in context. Those test results told me primarily about how he was doing when we were meeting, not about how he was doing years before on the evening of the offense. Although I acknowledge some of those items and some of the scales of the test do provide you with historical information, like whether you've ever been in trouble with the law, whether you've abused alcohol or drugs in your life, etc.
And is it uncommon that people who suffer from severe and persistent mental illness also have a history of drug or alcohol abuse?
Many people with severe and persistent mental illness also have problems with substances. We have a word for it. Sometimes it's referred to co-occurring disorders. A substance abuse problem along with schizophrenia, a substance abuse problem along with something like manic depressive illness, a substance abuse problem along with serious problems with depression. That's not uncommon at all.
What about, is it common for people with severe and persistent mental illness to also have problems, volatile relationships?
Some people with severe and persistent mental illness have volatile or very problematic interpersonal relationships, but not all of them, for sure. That in and of itself is not an indicator of severe and persistent mental illness.
What about Mr. Jonchuck's, you indicate he had a history of poorly controlled emotions?
Yeah, what we refer to as emotional lability, having difficulty controlling your emotions, or at least not controlling your emotions.
Is that consistent with his mental health diagnosis that you've issued in the case?
Yeah, it's consistent, and that supports my diagnosis of schizoaffective disorder.
Did you review some records from Dr. Arthur in reaching your opinion?
I did.
And
okay, guys, that's testimony going on right now on behalf of the defendant in his insanity defense. We got to do some business here at the Law&Crime Network and go to break. We'll be right back. Let's go back in the court on Jonchuck and listen to more of the examination of the doctor. Okay, so a little bit of a break there in court, which happens every now and again when you're either trying to get exhibits together or switching over from one lawyer to another. So essentially what we have here is yet another medical professional that's allowed to provide an expert opinion as it relates to insanity. Let's make a distinction here between a forensic psychologist or a forensic psychiatrist and just an ordinary one. These are people that deal, forensic is the term, in legal matters. The thing that I found interesting is the doctor, in layman terms, is trying to express something that is certain to be cross-examined by the prosecution, that is the over-objectification of symptoms in order to help himself out in a legal context, i.e. have a reason to say something that would help his insanity defense. So she doesn't use the word malingering, but that is actually the term that's in the DSM-5. It's something that every forensic psychologist and psychiatrist should look at. Let's listen to more of this testimony, and we'll be back.
It was worse at night.
There's a note here on the first page referencing that, and I remember reading that now.
Was there evidence that you observed that his that Mr. Jonchuck was experiencing great anxiety during the night and the days surrounding Phoebe's death?
I'm not sure I would say he was experiencing anxiety. Certainly that there was evidence that he wasn't sleeping in a regular way and that he was very active and taking care of a lot of things in the middle of the night. Phone calls and messages and email messages and text messages and things like that. I don't know if I would characterize that as anxiety.
Were you able to determine if John stopped taking his psychiatric medication at some point prior to December, January 2014, 2015?
I think I was.
Okay. What information did you receive about that?
Well, Mr. Jonchuck reported to me that he wasn't receiving mental health treatment from anyone other than Dr. Arthur while an adult, and then Dr. Arthur's treatment records stopped in December of 2013, and this offense occurred. At least a year later. So if he wasn't in treatment with Dr. Arthur wasn't able to continue prescribing medications. Mr. Jonchuck reported that the medications ran out at some point in time, and when they ran out, I think he gave me varying estimates of between 2 and 4 months, I think.
Okay. And did you observe in Dr. Arthur's records that Mr. Jonchuck had attempted to refill a Seroquel prescription in September of 2014?
There was a note at the very end of Dr. Arthur's records from a pharmacy, I believe, where he attempted to refill one of the medications Dr. Arthur had prescribed, but it was rejected. It wasn't filled.
What is Seroquel normally prescribed for?
Antipsychotic or psychotic symptoms. Also has some antidepressant and mood stabilizing effects.
When you met with John, did you ask him what happened?
Yes.
How do you go about getting that information? Do you start with very specific questions, general questions? Explain that to us.
Well, the way I do this and the way we recommend we do it in our training at the university in terms of how to go about doing these evaluations is that you start, one, let the defendant establish when he or she believes it's important to start. Do we need to start a week before this all happened, or maybe it's 2 months? So we initially let the defendant set the context in terms of where we start, okay? Because their perspective may be important. And then it's a bunch of this, and then what, and then what, and then what, and then what. And what we're doing as an interviewer is we're pushing the person we're interviewing to tell us everything they can remember about what occurred. So it's a lot of and then what, and then what, and then what, and it's also a lot of clarifications of pronouns. Because it's amazing how consistently when people tell stories, they'll be kind of letting you know what happened, and then the tendency is just to use she. So with Mr. Jonchuck, for example, he would say something like, well, and then I told her to do this. And, well, is that your mom? Is that your stepmom? Is that Phoebe? Is that the attorney? So there's a lot of, hold on, who is she? And actually, we start these interviews by saying, try to avoid pronouns. Try to give us names. So we try to get everything we can from the defendant. Now, obviously, before we evaluate the defendant, we know a lot about what went on based on reviewing the arrest reports, and maybe there were witness statements and things like that. So we try to get out everything we can from the defendant, and we also caution them, hey, all we want from you is what you remember. Don't tell us something that you read in the newspaper. Don't tell us something that your mother told you during her last jail visit. That's not your memory. What I want is what you remember, and how you were thinking, and how you were feeling, and how you were behaving. That's what this is all about. How were you thinking, feeling, and behaving at and around the time of the offense? And does that suggest you were experiencing symptoms of mental disorder at and around the time of the offense? And did those symptoms make it so you might not have known what you were doing, or might not have known the wrongfulness of what you were doing? So we do that, and then once I've determined, or once other examiners have determined, that they have, to the best of his or her ability, the defendant's recollection, all that he remembers, we might begin to ask them questions based on other information we have, right? At the grossest level, this is not referencing Mr. Jonchuck's case in particular, but you might have someone who said, oh, I robbed the 7-Eleven and then I just hung out and drank a beer with the cashier. Okay. Well, that's interesting because the cashier, when she wrote up her statement, she said you robbed the 7-Eleven and then you ran out as soon as you saw the police car show up. That's a little different. Help me understand that. Help me understand that discrepancy there. Or sometimes the defendant might sort of lay out his story, lay out her story, and there's other things you know occurred that she didn't report. He didn't report. Well, you know, whoever I'm interviewing, you told me about this, this, and this, but do you remember anything about this event? And sometimes the defendant says, oh yeah, I forgot that. Let me tell you about that. Sometimes they tell you, I have no memory for that. I don't remember that. And sometimes they tell you, oh, something like that happened, but that's not exactly accurate. And all we're trying to do is, as best we can, at least from one of the relevant parties, the defendant, get some information that will ultimately inform our opinion about how the person was thinking, feeling, and behaving at and around the time of the offense. And then we're going to compare that account to...
Okay, welcome back. So, Gene Rossi, what are your thoughts about the witness and the manner in which he's testifying as to his evaluation?
I'm not being flippant, Bob, but he really likes to talk and explain things. The mild critique I have is I had several experts like this. They seem to enjoy testifying and they talk a little bit too much. I hear a lot of, like, you know, pablum and bromides. I want to hear what specifically applies to Jonchuck. And all these 10,000 feet in the cloud comments, I'm not getting moved by this guy. I'm not feeling it, Bob. I'm not feeling it.
So let's talk trial tactics, Gene, since we both trained prosecutors for a long time. I'm evaluating this guy maybe for the first time. I see that he's very professorial. I see that he likes to talk a lot. So the first thing in my mind is I got to teach him right from the beginning and spank him in the nose if I need to, that I ask the questions and you answer them directly. You're not here in a lecture hall, professor. That's the first thing, and there's ways to do that. Because that throws the guy off his psychological game with the manner in which he likes to provide answers. Do you agree with at least that foundationally?
Oh, absolutely. And here's the thing, Bob, and you've done this, I'm sure. You got to do it in a way that doesn't insult the jury, and you got to show that you are in command on cross.
Exactly. All right, Gene Rossi, there's so much that we could do about it, and my law partner likes to say you are the expert with cross-examining experts. I love it as a science. I know a lot of lawyers are afraid of it. Maybe we'll have an opportunity to give our viewers a primer on how we go about preparing to do that. But first, we have to take a break. We're going to switch gears a little bit here to the Lindsay Parton case because there's some very, very important testimony. We have the forensic pathologist that's on the stand talking about the injuries to this beautiful 3-year-old girl. She doesn't want her face seen, the forensic pathologist. That's why we're looking at the defendant. Let's take a listen in court.
Neurons, the cells that make up the brain, are damaged. And if the force is sufficient, the person can't survive. What I saw at autopsy was the result of the shearing injury to the actual brain itself. When the brain is damaged, the only thing it knows to do is call for more blood and for more oxygen. That's what it does. So the body sends more blood to the brain because the oxygen is carried in the red blood cells to the brain. The brain swells because it's calling for more blood because it's damaged. The more it's damaged, the more it swells. And it's a big cycle. Because the brain is damaged, the blood vessels within the brain are also damaged and they become leaky. So what we see is spots of blood within the brain itself. In an autopsy, 10 days after she was injured, I saw actual blood in her brain, hemorrhages in her brain. Her brain stem and her spinal cord had the results of the shearing injury to the brain itself from the force transmitted to her head.
Doctor, we've heard testimony that in providing care to this child, the EMTs scooped up the child, putting their hand behind the child's head and holding the child to their body as they rushed her out of the home. Could that explain that neck injury in State's Exhibit 83 that we saw?
Not at all.
Doctor, as part of your forensic evaluation, do you also review medical documentation from whether it's a medical history, from normal medical visits, whether it is hospital records, things along those lines regarding that specific patient that you're evaluating?
Yes, I do.
And did you do that in this case?
I did.
And why do you review those?
It's important for me to understand the whole picture of my patients. These are my patients. So I want to know what medical diseases the person has had documented before, because sometimes medical diseases can mimic an injury. I reviewed her pediatrician records. I reviewed the emergency medical services records. I reviewed the records from Fort Hamilton Hughes and also Children's Hospital.
And within those records, did you find anything to explain the injuries that you saw?
With regard to natural disease?
Yes.
No.
Doctor, to a reasonable degree of medical certainty based on your training, education, and experience, do you have an opinion as to what caused the death of Hannah Wesche?
Yes, I do.
And what is that?
Hannah died from traumatic brain injury due to blunt impacts to her head.
Doctor, is it your opinion that blunt impacts explain all of the injury that you see?
Yes.
Doctor, what is abusive head trauma?
Abusive head trauma is a term that physicians use if they are clinical physicians, treating physicians. We as pathologists don't use that term. We classify fatalities by manner of death, as I've done here. And I think that my classification encompasses that phrase. But in the clinical world, treating physicians use the term abusive head trauma, but we don't.
And doctor, when we talk about blunt impacts, are these simple? Could these be simple falls that you're talking about?
Do you mean blunt impacts in general or for Hannah?
Regarding the traumatic brain injury that you found in Hannah.
Oh, no.
Would a simple fall be sufficient to explain that?
Absolutely not.
would a fall being held by an adult, while being held by an adult, would that explain the injuries that you saw?
From ground level, a simple fall cannot explain this injury. This is much too great a force.
And to a reasonable degree of medical certainty, do you have a determination as to the manner of death of Hannah Wesche?
Yes, I do.
And what is that?
The manner of death is homicide.
In layman's term, what does that mean?
It means death at the hands of another person.
Do you have an opinion to a reasonable degree of medical certainty as to whether or not Hannah could have been walking or talking or behaving in a normal fashion after receiving the injuries that resulted in her death?
Yes, I do.
And what is that?
She could not.
How are you able to say that?
By my medical training and by my own experience, this is a tremendous brain injury. This is really serious. This is a tremendous force to the brain itself. When the brain is injured to this degree, to cause a death in this child, the brain can't function properly right away. She would be neurologically abnormal right away, probably unresponsive within moments. This is really serious.
All right, doctor, and do you have an opinion with it to a reasonable degree of medical certainty as to how quickly Hannah would have become non-responsive receiving that injury?
Within moments. She couldn't be normal after just a few moments, really.
So I may have just a minute.
Take your time.
Okay, so we're taking a break there. That is a very powerful witness. The prosecutor, Gene, did a very good job of going very slowly with complex testimony, but moreover, not only to show within a reasonable degree of medical certainty what the cause and manner of death is, but what it was not. And the most powerful testimony, and I've seen that missed many times by homicide prosecutors. And the thing that was clear was that she then went to, secondarily, the defense's case that this could have been done by falling and hitting a head on a bathtub or some simple fall. And that expert was very clear. The trauma here was far, far, far in excess of what you would expect from that kind of trauma. Powerful witness.
Bob, you know what's great about this show, among many things, is we saw a direct examination of that expert in the Jonchuck, who, engaged in a lot of words. This direct exam in this case, the Parton case, was textbook. Mm-hmm. That prosecutor and that witness were outstanding.
And to your point that you mention all the time, Gene, this is complex testimony with lots of moving pieces. There's legal jargon that has to dovetail with medical stuff. This was not the first time that the prosecutor and this witness have met.
That's correct. And what was great is the prosecutor asked very simple questions and very direct questions about the victim. And that's key. Comparing the legal terminology to the facts of this case, that's what you have to do in simple terms.
Yeah, what I loved about what this prosecutor did here was that she not only, as you say, Gene, in simple terms expressed complex legal medical terminology, but at the same time, she went forward with what they're saying the cause of death is, but more importantly, eviscerated the defense's argument through the very same witness. Very powerful. Going to break. We'll be right back. Cross-examination has begun of this expert witness. It's getting salty already. Let's go to court.
Makes a report about him.
No. So what the investigator does is records information that is supplied to him and documents that in our database.
And then you evaluate that as a part of your duties in performing the autopsy and writing the reports that you referred to?
Yes.
Okay. But you don't know where it is. You reviewed it in preparation for this testimony?
Yes.
Okay. But you haven't supplied it to the state, to your knowledge?
I can't answer that question because that's not my role.
Okay. Okay, but you've reviewed it?
Yes.
All right. And it's part of your knowledge and understanding of the events that you've relayed to the jury here?
I believe so.
And it helped you to inform some of the opinions that you've supplied to the jury today?
I'm not sure I can go that far.
Well, since I've never seen this, I guess I'm flying in the dark, but I guess it would include a history? History?
History?
History?
History?
History.
Is that a question?
Yeah. My question was, stop being coy with me. I asked you if it would include a history.
Yes, it includes a history. I told you it includes a history.
Just answer my question. It includes a history. Yes?
The investigator report includes the history as given to the investigator.
All right. So some unknown investigator in your office prepared a history that's part of the records that you reviewed to refresh your recollection and testify, right? Yes?
No, the investigator is not unknown, and it's not prepared, it's recorded.
Who was the investigator in the case?
I don't know.
Okay. So the investigator's not unknown, but you don't remember?
Right.
Okay. And answer my question and only my question. Do you remember what the history was? Do you remember what it was?
Yes.
Okay. But you don't know who made it?
So our investigators don't make the history, they record what's given to them.
Right. That's the same question. You don't remember who made it. You read it, it's in your mind.
The facts of Hannah's demise are in my mind. Correct.
The opinions that you gave, which are two that I counted, do not extend to the perpetrator of the blunt impact trauma.
They do not include the perpetrator of the trauma. I don't know who that person is.
Thank you. Your opinion does encompass the mechanism of injury.
Yes.
Your opinion is blunt impact trauma. Yes?
Blunt impacts to the head, yes.
Okay. Specifically to the back of the head.
Well, I showed you where the blunt impacts are. She has some on the sides also.
Do we have a problem together here? I mean...
So, what I'm hearing you say... Yeah. I object to your trying to limit my testimony. You're asking me to the back of the head. She has impacts to the back of the head and to the sides of her head.
Okay.
I want to be complete.
Well, let's get things straight. You're a witness, right? Yes?
Yes.
Okay. You're a state's witness, correct?
I'm a witness. Yes.
Okay. You are an employee of the state of Ohio or Hamilton County, correct?
Hamilton County.
You testified that you've testified as an expert in municipal court.
Yes.
You've testified as an expert in common police court.
Yes.
You've testified as an expert in federal court.
Yes.
When in all of those experiences have you objected to an attorney and the questions that he asked? Is that your role?
The attorneys have been clear before. I've never had to before.
All right. All right. So this is the first time in all your experience that you've mustered it up and made an objection to an attorney? Is this the first time you've done it?
Other people have been very clear.
Okay. Now let's get back to the questions that I was asking you about, which is your opinion extends to blunt impact trauma to the back of the head, correct?
It includes that, yes.
Okay. And I think you showed us the two relevant images, which were State 76 and State 79, right?
Yes.
Okay. Do you have those with you?
What I have is 83, 80, hold on right here, 81, 82.
Go ahead. She's got a couple. And that's, let's see. I'm going to try. All right, that's not the one. Back. Blank image. There we go. I got it. I put in front of you State 76. I got you. That's okay. That's State 76, correct?
Yes, sir.
And that's the outside of Hannah's scalp?
Yes.
Okay, and that's the blunt force trauma that we've talked about, correct?
In part, yes.
All right, and then there's internal bruising that you also talked about from State 79, right?
Yes.
Okay. You testified that your autopsy was performed between the 19th and 20th of March 2018, correct?
Yes.
All right. And upon completing your autopsy and making the discoveries that are depicted in 76 and 79, you called a detective in the case to explain or tell him about the significant bruises that you found in the back of the head.
I believe so.
Okay. And I'm not going to put words in your mouth, but I think you said Hannah had a severe raised and swollen bruise, maybe bruises, on the back of her head. That's what you told him.
Okay.
Okay. Would you characterize?
Honestly, I don't think I said raised. I wouldn't have used that word.
Okay. If the police report contains that information, it might be incorrect.
Sometimes police write things that they think they hear.
Right. Which is a problem in all narratives and histories, right? Sometimes people write down things that are wrong, or they hear wrong, or they're said.
Or in their mind, that's what the word was, right?
But what I'd like to ask you is this injury on 76, is that insignificant to the cause of death?
That injury alone did not cause the problem.
Well,
That injury alone did not cause her fatality. It is a marker of the severe force that went through her brain. That's the problem.
Right. It resulted in the hemorrhaging and the mass effect and the midline shift and the brain swelling and the herniation.
Yes.
Right. But that certainly is an important bruise, right?
Yes.
It's not slight.
No.
It's not mere inflammation.
Mere inflammation.
Just mere inflammation. It's not some ordinary, merely inflamed tissue.
It is not insignificant, correct.
Okay. And if other physicians would have come prior to you and suggested that it was insignificant to her condition and her death, they would be wrong.
No, I can't say that, because treating physicians see things from a different perspective than pathologists. I didn't see those bruises either until I shaved her hair. I didn't know they were there until I shaved her hair. I wouldn't blame anybody for not having seen them. And if asked the question, were those bruises themselves the problem? The answer, as I've just said, is no. It isn't the bruise that's the problem. The bruise is the marker of the force that was transmitted to the brain that's the problem.
The problem is the blunt impact force to the head.
The force, yes.
Right. And that is the marker of the blunt impact forces because that's where the force occurred, the back of the head.
Well, she had that, and she had some bruises on the side as well, so I can't exclude those.
Right. We can agree that you were the one that found the bruises depicted in 26, state 26, at autopsy. I'm sorry. Should I get the right? 76, thank you. So strike that and start.
Okay, Gene Rossi, let's talk some cross-examination. The producers are fascinated about what's happening here. Let me start with something that I learned from somebody who was a phenomenal cross-examiner of experts, and it went like this. You look at an expert like they're in a cage, like a bear in a cage, and then you lock that cage, and then you check to make sure that cage is locked, and then you check again. And then you get a 10-foot pole, and you poke that bear and then run away. And then you go back in and you poke the bear in the other way. Because if you decide to open up that cage and get into the cage with the bear, you're going to get torn up. In other words, this expert and any expert has far more knowledge than you do. Your cross-examination on the science usually will not win. So talk to me about that and a little bit of the acerbic attitude and how that comes off to a jury.
Okay, first off, I got to correct you. I would not use a 10-foot pole. I would use a 15-foot pole. Okay.
And you've got longer arms than me.
Yeah, whatever. But you're right about the whole cage. My view of crossing an expert is always assume they're smarter than you and always assume they got an answer. And what you try to do is get them to admit certain facts that may help you and that will help the expert that you may call. Number two, in terms of demeanor, there's constructive cross and destructive cross. Constructive is you're trying to get out facts that can help you. Destructive is you're almost attacking and getting in the cage. The one major mistake he made among several is he made the cross about him.
Right.
He said, are you telling me that you have never had a problem with, that I'm the first person you've ever had problem with their questions? Yes.
Yeah, so
why would you get in the bear's cage and debate that one? She was a phenomenal witness. Now, there was a couple of times where she got a little prickly unnecessarily, but he was making it about him, and that's not a good cross.
When he got the answer that I don't know who did this, but I can just tell you, you know, the circumstances could have been enough for him to walk away if you got a good witness, because you got to know when to fold them. But to the exact point you just raised, Gene, the thing that got me with that kind of line of questioning, like, oh, it's just me? And she goes, yeah, because your questions aren't clear and not precise or whatever she said. I was wondering, because I always get the transcripts of previous testimony of witnesses, and I thought he was about to, like, pull out, well, how about in State versus Smith, where the judge had to ask you 5 times to answer the question, or in Jones versus Jones, where 3 times you were told to, you know, blah, 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 but he didn't. So it's just, oh, so I'm the only one reinforcing the answer. And now maybe he'll come out with that later on, but it showed to me an immaturity if he has nothing to back that up in the cross-examination. Right now, that bear is controlling him and throwing him around in that cage. My suggestion would be, if he doesn't have a wowsy in his back pocket, is try to do your best, as much blood is in your eyes right now, to crawl out of there with those marks on your back and run away.
Absolutely. And if you look at the defendant, she's not keeping a poker face. And I don't know if she's enamored with the style of her own attorney.
Gene, you know, that's a great point. I educate my clients on this. My speed is multiple. You got to have a fastball, you got to have a curveball, you got to have a screwball, you got to do a changeup. Not every witness deserves the same kind of cross-examination. Yet you find some defendants or some people that love to see you screaming and yelling, even though you may not be scoring points, and moreover, maybe turning the jury off. They may be satisfied and feel, oh, they're screaming back, but it's not accomplishing anything.
No. I just listening to that, I would not start off my cross, and I hate to be a Monday morning quarterback, but we're paid the big bucks.
Hey, listen, they used to Monday morning quarterback us, so why not? You know, let's return the favor. Yeah,
I would not spend 10 minutes of the beginning 10 minutes of your cross getting her to admit she reviewed documents. Of course she reviewed documents. Who cares?
Well, Gene, the most important way that I have unsettled expert witnesses right from the beginning is to say, of course you want all the data. You want all the information. You know you're coming in here to swear an oath. You're going to testify before these folks. You're about to give an opinion. So certainly you want to make sure nothing was withheld from you, that you didn't have an opportunity to see something. Yeah. If you know, because it happens a lot of times, the lawyers don't give all the file. You've already disarmed them by sewing them into they want all the information, and then you're letting them know they were deprived something. That's a really good start. It doesn't have anything to do with the expert science, and you can really unnerve the witness. I don't know. My point of view, Gene Rossi's point of view, but we also got to take a break, and that's a point of view, too. We'll be right back. Let's go back to this testy cross-examination by the defense of the state's pathologist.
Lucid interval is the time between injury and the development of neurological symptoms, so he has defined it. Yes?
Yes.
Okay. And you understand that to be lucid interval?
Yes.
There's no dispute about that definition?
Nope.
Some pediatric head injuries are associated with immediate neurological symptoms, while other head trauma is associated with a lucid interval of variable duration.
Yes.
So it's, some don't have it, some don't.
Yes, your question was about Hannah. This doesn't apply to Hannah.
I understand. Well, that's your opinion.
That's
right?
what you asked me, yeah.
Well, I didn't ask you about that, but okay. The likelihood of having a lucid interval depends primarily on the amount of shear injury to the brain and the region of the brain that sustains the injury, in addition to other factors such as the presence of subdural or epidural hematoma, traumatic axonal injury in the brainstem or spinal cord, and brain swelling. So you have to look at all those factors and make a determination diagnostically as to whether or not a lucid interval is possible or not.
Yes.
He goes on to say, in 80% of children with head trauma, symptoms happen within 1 hour following injury. Yes?
Sure.
Okay. Well, 1 hour is different than moments, or whatever you said. Yes?
You didn't ask me about the population of children with head injury. You asked me about Hannah.
Right. And I'm redirecting my question back to that. So I wrote down what I thought I heard you say, and your opinion testimony was right away. Yes?
So yes, with the severity of Hannah's injury, yes, she would be neurologically impaired right away.
Right away. Okay. And you agree with me that you don't measure time in segments like right away or relatively immediately. That's not how we measure time, is it?
We're not talking about measuring time. You're asking my opinion about the injuries. That's the best as I can do.
You know what? I get to ask the questions. I'm asking you about time. Okay? Don't be coy about it. We're talking about time. I just said right here we don't measure time in moments or relatively immediately or vague descriptions like that. In a case like this, where time frames are important, we measure it in seconds, in minutes, in hours, or something beyond that, in not vague terms. Am I right?
No.
Okay. That's enough. No matter how you measure time, Dr. Spitz measures it in hours. Yes? That's how...
I can't draw that conclusion.
Okay. In the course of your work in this case, did you perform work as to what the exact time frame in this case was with respect to the defendant here? Did you do that work? Is my question.
I don't understand by work. So I documented her injuries.
Yes.
I reviewed her medical record. Okay. From my conclusions about the severity of her injuries, okay, I've told you what her time frame for neurological impairment was. Right. So if that's what you mean by work, that's what I did.
Okay. No, I appreciate that answer. But and maybe I did ask you a vague question. My question was, you have no idea how much time Hannah had with this defendant.
That's not my role.
Okay. So your testimony, your opinion, everything that you said to the jury has nothing to do with that, right?
That is not my job, correct.
So correct.
Correct.
Right. And you were not, you didn't see fit to evaluate text messages and phone logs and histories about the amount of time that Hannah was with the babysitter the defendant was with.
That's way outside my scope. No, I did not do that.
Right. Would you recollect whether or not this investigator's report had that information in it?
I don't think it did because that's not our role.
Okay. Okay. And your autopsy was performed again on the 19th and 20th?
Yes.
Okay. That was after Hannah had brain surgery?
Yes.
Okay. She was on life support from the 8th to the 18th?
I believe so, yes.
Okay. She was on an artificial ventilator?
Yes.
Which means that oxygen was being artificially sent to her brain to keep her alive?
Yes.
Okay. And I don't know the answer to this. Was blood being artificially sent to her brain too because her heart wasn't working? I don't know what the answer is.
No.
Her heart was working?
Yes.
Okay. But it was the oxygen?
Correct.
Okay. And having looked at Dr. Spitz's report, you know that he is of the belief that the use of the artificial ventilation causes brain injury itself.
That's not what he said.
Okay. And if he, all right. That's so you don't believe he said that in the report. Is that it?
Yes.
Okay. I could have 1 second.
Take time.
Oh, man, Gene, let me see if I got this right. During the course of the cross-examination of this very contentious lawyer who I think, hey, I know you mean you were a little different than this. I'm on the aggressive side. I like to really get into people's faces. But it's got to be equal force. It's got to be mutually assured destruction. I try not to go heavier. So I think he's over the top. But I'm curious. I'm not sure if I heard this correctly because I'm a little bit, it's not early, but it's tiring. Did he say to her, I don't know the answer to this, whether it was from the heart or from the brain with the oxygen, and asked her to educate him as to the science? Did I actually hear a lawyer on cross-examination essentially admit, I don't know some basic biological things?
He did, and it was during the portion where he's asking about the 10 days she was on life support. So I don't know why he's asking questions about the 10 days on life support. That doesn't help your client unless there's some evidentiary reason that his expert can talk about. But here's the thing. When I was doing my prosecutions, if he ever acted the way he is right now, in my federal courtrooms, a judge would have reamed him. He's been arguing with the witness. He's been surly. And I don't know what's going on. It seems like there's this personal vendetta between him and Dr. Dean. And that's not a good formula for a good cross.
Yeah. Again, if you're really getting obstreperous answers, but these are really, really gratuitous comments, especially because in many instances she is in fact answering the question. The question is poorly put. It could be as a prosecutor, I've done this, you've done it, I know for a fact that you could object to either the introduction of inadmissible evidence or the manner in which a witness is being cross-examined or the fact that he's making these speaking gratuitous comments. But you kind of lay back a little bit. I mean, at least I've done it. I know my witness can handle it. And it's only making the lawyer look bad in front of the jury. In fact, I'm looking in the chat room, and I'm watching people who are disturbed by the guy, and that's exactly what you want your jury to feel.
Yeah, I would not object at all during this cross-examination. Let him hang himself on his own petard, if that's the phrase, because when you come up for redirect, you're going to be very professional and polite. And that redirect is going to be very good for the government. That's my opinion. Hoisting
on your own petard. Only on the show with Bob Bianchi and Gene Rossi in one episode can you have references to Dante Alighieri and to Shakespeare. And the analogies will never end. Polenta, all in one show.
Polenta.
And Polenta. And Brajol. We threw a little Brajol in there earlier, Gene.
Absolutely. We got it all, baby. We got it all.
You know, we got the great trial. We got the great gavel-to-gavel coverage. We got the great authors. We got the great Italian food. Now we're going to have a great break, and we'll be right back. Let's go back to more of this surly cross-examination of the state's forensic pathologist.
Is my giving information to them about the findings. I do not recall any information imparted to me during the autopsy. I don't.
do you have experience enough to know whether or not the coroner's investigators that, I know you don't call them coroner's investigators, the investigators from your office that performed this investigative, that completed this investigative report, do you know whether or not they would have spoken with the detectives that were present at the autopsy?
I don't know. Sometimes they do, sometimes they don't. So,
go ahead.
May I please explain this?
Yeah, no.
Okay. So in our office, we have a database, and we record information and correspondence and so forth. Investigators type in there too. So the initial report was taken by an investigator, and additional information is added. It's in the documents section in our database. That's what you're talking about.
The investigator that did the investigative report wasn't present at the autopsy?
I don't believe so.
Good. Yes, I'm done. The defense wants to approach briefly.
Get ready, Gene. Hi. Okay. Gene, you're still with me there, right? All right. You know, I'm trying to quantify or qualify all of the various chatters who I always love to identify about what their thoughts were on this cross-examination. And boy, there was a lot about this expert testimony, most of which, in fact, I don't think I saw a negative comment about the expert holding her composure. So I have to try to encapsulate it, folks, for our audience out there, our great chatters. If you ever get a chance, get into that chat room, because I think these guys are awesome and they give us great insights. And we love answering the questions they have and the observations they have. But it's got to be from Lil 1955, kind of, I think, quoted the sentiment the most. Quote, "I loathe this attorney, Gene." It's pretty rough. But I think that was a general sentiment captured. And it goes to show you, you can be aggressive. I am very aggressive. Now, maybe somebody loathed me as well, but I try not to be more aggressive than the witnesses on the stand, recognizing that I'm in the power relationship there and being very, very careful watching that jury that I'm not agitating anybody. So I think he was just taking too many pot shots when she was answering questions pretty specifically and didn't warrant it. And I think the prosecutor was smart to just stand down and make the jury feel like Lil 1955 said that they loathe him. I don't know. What do you think?
You know, we've been pretty hard on this defense attorney, but I hope there was a cross-examination where I'm convinced the jury loathed me. It was 1991. I was horrible, Bob. I did everything wrong. I did a lot of what he's doing, and that was 1991. And I learned from that loathing mistake that I made in Cleveland, Ohio, in front of a jury.
You know, funny, I since we're telling a little war story here, I knew a guy who could not win a case if it had guilty written all over it and was handed in a bow and a box to a jury. Not guilty, not guilty, not guilty, not guilty. He was older than me. He came to me and asked me, you were in court when I was doing summation, and the judge seems to think I'm obnoxious, and the jury's finding the case is not guilty because they hate me. And I was like a young baby prosecutor. I was like, I don't know nothing. I didn't want to say it. But he tweaked his style just a little bit. And we used to say kind of, it was like almost like he sold his soul to the devil. That's not what it was. He tweaked his style just a little bit, took a little zip off that fastball on his crosses, on his openings. He didn't strut around the courtroom like he was the smartest guy. Then the guy couldn't lose a case. He became dead.
Absolutely. Absolutely. I'll tell you a war story. I did a cross of a defendant who was a doctor, pain doctor. And the first part of my cross was an hour before lunch. And during my lunch break, a colleague come up to me and he said, "Gene, take it down a notch. You're a little too high octane," because it was like a 5-hour cross. And when we got back from the lunch break, I took it down a notch and I did much, much better. But I had a colleague tell me, take it down a little bit. because it is stressful.
Yeah, and you know, it is. And a good, you know, observer, this is an art form. It's not 2 + 2 = 4. Courts are based on witnesses and human nature and the foibles that the witnesses have and we have, and you've got to really be in control, know everything that's going on in the courtroom. I remember we used to start off in a juvenile court, they would call it, where it was only a bench trial. So you kind of got to get on your feet and get it out there. And the judges back in that day, things have changed a lot, were allowed to bring the lawyers in, both lawyers at the end of the case. I was only 25 years old. And he would say, why did you do this and why did you do that? He was a great lawyer. The judges at the time used to be the smartest people in the courtroom. But he said to me, you know what, Bianchi, you know what you remind me of? He goes, you're going to be okay. You're going to be really good. But you are like a tiger in a cage, man, up and down, a lot of energy. And so you take that into consideration. So by the time we got to those jury trials, you know, we were much more cognizant of how we looked, how we approached every single thing. I used to train my lawyers. Don't think that there's a thing the jury is missing. You need to bring life into it. Use your common sense. Let them know that you're real. Moreover, most importantly, that you are to be trusted in what it is that you're doing in that courtroom.
Well, when I used to teach baby prosecutors, I'm gonna modify it a little bit. But one fellow instructor says, in a jury trial, always be yourself. Unless you're a blank, then be somebody else.
Okay. and who's the person that would tell you if you're a blank? Because
your colleague.
Because Gene, I used to say to my people, I used to have a mirror like on the side of where my desk was. My staff used to laugh every time somebody thought that they were, the best person, this and that, the kitty boo boo and all the crying that would go on in the prosecutor's office. I used to stand up and I would look in the mirror, and eventually they got it. They laugh, and I'm like, I look in the mirror and I see a paunchy, balding, middle-aged guy. Why is it that everybody else looks in this mirror and sees Brad Pitt?
That's awesome.
Sometimes it's hard to do self-reflection. I don't know what's happening in the courtroom right now. I think they're taking a break. So we are going to, I assume, Gene, if you give me permission to, take a break ourselves? Is that okay?
That's fine.
Okay, let's do it.
That's fine.
I got to give you an update on that last cross-examination by the defense lawyer of the forensic pathologist in the case, because there was another classic that sums it up. I just got to do it. Thank you guys in the chat room. You're giving me that. You're giving me material. This is a non-6632 that says, gee, this level of jerkness can't just be turned off and on. And I'm not trying to give the guy a hard time. I'm just trying to say that this is what the jury's thinking. If our chatters are thinking that this is what the jury's thinking. Gee. I'm sorry, I'm going to throw the producers off their game here. There was an emergency room physician that testified in this case that was very powerful. Let's take a look.
So on page 6 at the top, it says right side mandibular area with ecchymosis, superficial abrasion, contusion, and the chin appears with contusion, ecchymosis.
Okay. Contusion, what does that mean?
Bruising.
And I think you said ecchymosis, that's also bruising?
Mm-hmm.
So just two different words, or is there a difference between ecchymosis and contusion?
No, just the same.
Okay. And you also said abrasion. What are you talking about with abrasion? What is an abrasion?
There's a breakage of the skin.
Did you do an evaluation of the eyes of Hannah Wesche?
Yes.
And go ahead.
Oh, sorry.
Go ahead.
Also on page 6.
Also on page 6, thank you.
Right pupil approximately 4 to 5 millimeter, non-reactive. Left pupil approximately 3 to 4 millimeter and sluggishly reactive. The conjunctiva is normal. Periorbital ecchymosis or bruising, left, worse than the right, with no crepitus and bilaterally no deformities. Fundus exam showing blood bilaterally.
All right, and we had a lot of medical terms in there, so I just want to make sure that we understand what you're talking about.
Sure.
All right, and when you say right pupil, you're giving a measurement 4 to 5 millimeter, that's the measurement of the pupil?
Correct.
When you say sluggishly reactive, what are you talking about? What do you do to make that measurement or determination?
Reaction to light response.
And so could you explain, just in case there's some of those of us that maybe don't understand what that means or what the eye is supposed to do?
Sure. So in a dark area, the pupil dilates, and you shine a light in there, the pupil will constrict. And that's so when we shine a light in, we kind of look at how it reacts.
Okay. And so in this instance with Hannah, did her pupils react when the light was shined in her eye?
Looks the right did not, the left very slowly.
Okay. And is that abnormal?
Jet. So she arrived in the emergency department unresponsive. She wasn't protecting her airway, so made the decision to intubate and put her on the ventilator.
And when you say intubate, what do you do to intubate?
I put a breathing tube down her throat and help her breathe.
Did you administer any other type of treatment or medication?
We gave her medication to facilitate the intubation.
Okay. During intubation, could you have caused any of the injuries that we've previously seen that you circled?
Absolutely not.
Would that have caused any injuries on Hannah during the intubation externally?
No.
Did Hannah ever require CPR while at Fort Hamilton Hospital?
No.
Did you contact any outside hospital for assistance in treatment with Hannah?
Yes.
And who did you contact?
Cincinnati Children's Emergency Department.
And based on that contact, what was your plan of care?
We were to intubate her and set up for a air care transport to their emergency department.
And then did you do that?
Yes.
While at Fort Hamilton Hospital, did you order any additional screening?
Yes.
What did you order?
A CT of her head, her neck, and her face.
Okay, so, listen, this is important testimony because I got to go through everything about the rescue efforts, make sure there's no intervening causes, try to eliminate any kind of defense to that. Plus, it's part of the case. It's the ER doctor. There were also ICU doctors that testified. Firstly, before we get to them, for all you chatters that are in there, thank you so much for all the compliments for this show and with Gene and myself. We really appreciate it. And yes, we do love watching your commentary. You not only made us laugh a little bit, but you always have great insights. Let's go to that ICU doctor.
So from when I took over her care, all the surgical procedures had already been done.
All right.
So when I took care of her, at that point the surgical procedures had been done, and from when I took care of her onwards, there were no new surgical procedures performed.
All right. And when did you take over care?
I took care of her on the 9th of March.
And did you 2018? Thank you.
Yes.
And how long did that care continue?
So it was for a week.
In your care, did Hannah ever regain consciousness?
No, she did not regain consciousness.
Did her condition change in your care?
Her neurologic condition continued to deteriorate under my care, and that was what changed predominantly.
Doctor, can you tell us whether or not there was ever a determination of brain death in this case?
There was a determination of brain death in this case, and that was what was performed ultimately that led to her death.
Do you recall on what day the condition progressed or changed significantly in your care?
I'd have to look at the records, but it was about 3 days into her being in the hospital, it became clear to us that we would not be able to reverse the processes or even temporize what was going on in her brain. And at that time, we started thinking about doing a formal assessment of her brain by doing what we call a brain death examination. And so it was about 2 or 3 days into her course at Children's Hospital that it became very clear that this may go down the path of brain death.
Now, did that brain death evaluation then occur 3 days into her care?
No, it could not occur 3 days into it because for us to do a brain death examination, the patient has to have no medications in their system that would actually blunt or sort of cloud the neurologic exam, and she had gotten a lot of medications to induce a coma to help her brain and the pressure in her brain, and the levels of one of those medications was too high, and that precluded us doing a brain death examination.
So when ultimately were you able to do the brain death examination?
So I don't remember the exact date, but it was done. I had finished my week and I had passed it on to my partner, who had taken the case over, and we were just waiting for those levels of the drug to come down to a level where we would be able to do it. And that was done the day she was pronounced, the day it was done. And so when the level came down, we were able to do it.
During your care of Hannah Weshy, were you able to see visible external injuries all the time?
So while in the intensive care unit, we children are kept pretty still, and what I was able to observe was some bruising that was notable on her upper chest, and I didn't really turn her much because we were in a medically induced coma and she was so fragile at that state, so we don't like to move patients a whole lot, and so didn't really look at her back a whole lot, but definitely in the front when I used to examine her every day, we didn't notice bruising.
Oh. And could any of the care that Hannah received within the ICU have caused external injury to her?
No.
And why not? How do you know that?
Because children who have had sustained very severe brain injury, we keep them very, very...
All right, Gene, so listen, compelling case, good testimony coming in, prosecutor doing a really good job. your final thoughts as to how you think the case is going so far.
I think Dorothy Dean was probably the best witness they could possibly call for the government. I thought her testimony was clear, cogent, simple for the jury to understand how her brain expanded, why it expanded, and that just falling on the floor while being held is not enough to cause that severe trauma and all the injuries to her head.
Yeah, what a shame. What a shame. These little kids being killed like this. Gene, before you go, my investigative skills and tell me that you may be playing basketball outside tonight. Is that accurate?
Oh, I was talking to the deputy commissioner of the Hoop Madness Club of Alexandria, Virginia. I'm the commissioner.
Very impressive. I will be doing Muay Thai. Let's see if you guys can figure out what that is tonight as well. But anyway, it's been a pleasure for all of us here at the Law and Crime Network. We all thank you so much, our chatters, our viewers, all the great people in the back that make all this happen. I'll be back next Monday. You have a blessed week. Be well.